balance of my time.
The gentlewoman from Texas reserves. The gentleman from Ohio, Mr. Jordan, is recognized.
Thank you, Madam Speaker. Yield such time as I may consume.
Gentleman's recognized.
Thank you, Madam Speaker. H.R. 3372 authorizes the Attorney General to provide grants to community-based nonprofits to operate one-stop reentry centers. The biggest problem, though, is the Department of Justice already does exactly what this bill would require it to do. The Second Chance Act of 2007, reauthorized by Congress and signed into law by President Trump in the First Step Act of 2018, provides comprehensive assistance to individuals in transition from prison back to the community. This bill is duplicative, it's redundant, and maybe most importantly, the Democrats know that. Last Congress, the Subcommittee on Crime, Terrorism, and Homeland Security held a hearing. The majority's own briefing memo for that hearing highlighted the reporting center in Somerset County, Pennsylvania. And the center said this: it was a community-based correctional program that has been designed to provide services for its participants at one location. This is the exact type of program outlined in H.R. 3372. And indeed, the center's program received a grant from the Justice Department's Bureau of Justice Assistance. In fact, the name of that grant is Smart Supervision, Reducing Prison Population, Saving Money, and Creating Safer Communities. H.R. 3372 is duplicative of efforts found in the Second Chance Act, under which nonprofit entities are eligible for grant funds. While we want successful reentry programs to reduce recidivism, we should not be creating duplicative and additional bureaucracy in the process. Also, the bill encourages state, Indians, tribes, and local governments to employ sex offenders, murderers, and human traffickers and other dangerous criminals to operate the reentry service assistant hotlines. H.R. 3372 authorizes $7.5 million in grants to states, Indian tribes, and local governments to operate these reentry services assistant hotlines that direct individuals to local reentry services. It requires the Attorney General to give preference to applicants who would employ people to operate the hotlines, quote, who have been convicted of an offense or have served a term of imprisonment and have completed any court-ordered supervision. But the bill provides no exceptions for violent offenders such as sex offenders, murderers, human traffickers, and other dangerous criminals. While it might be appropriate to employ certain offenders who have demonstrated full rehabilitation, Congress should not be incentivizing local communities to hire certain offenders who may not have been rehabbed. What should we be doing? Spending our time, our limited time, in addressing the rampant crime epidemic in America's cities, rejecting lenient soft-on-crime policies, and encouraging prosecutors to actually enforce the law. Madam Speaker, we reserve the balance of our time.